Hello and welcome to Unpacking the Case, the podcast by Davitt Jones Bold, the real estate law specialists. Today, and as ever, I'm joined by Richard Snape, our head of legal training. Hello, Richard.
Hello, Lizzie. It's been so long. I haven't seen you much at all lately.
We have only just had 2 webinars this week, so we've seen a lot of each other. So today's podcast is following your webinar on the 23rd of September, which covered residential and mixed-use developments, looking at building control, cladding, and some other legal considerations. So today, I think you're going to be mainly focusing on service charges and some cases in that area. So do you want to start with talking about service charges and the difference between residential and commercial service charges in mixed-use developments?
Yeah, I mean, there's major differences. If truth be known, landlords and the managing agents would much rather manage commercial properties than residential, but that isn't always possible. And as you appreciate, for many years now, the local authority planning permission has looked towards mixed-use development with offices or shops or whatever down below and residential flats up above. If you've got a commercial property or a commercial unit within a mixed-use development, then there is no statutory control of service charge. What the lease says clinches everything. There was a case back in 1976 called Finchbourne and Rodriguez that said it must be implied that the service charge liability and requests must be reasonable. And I think that's accepted. It would only apply to residential properties. I did actually mention, and they're in the notes for the course, a couple of recent cases, one from late last year, which is Sorin Hossain and Black's Outdoor Leisure, and another one from earlier this year, which was Criterion Buildings and McKinsey. The first case was Court of Appeal in the first instance, and they both basically confirmed the fact that in the absence of fraud or manifest error or mathematical mistakes, whatever the service charge provisions say clinches it. So there's very little you can say about commercial service charge liability, practically no statute. I should stress, though, I did mention this in the notes, but a lot of people, I've talked to so many commercial property lawyers who don't appreciate that once you're into the world of mixed-use developments, where it depends on the circumstance. If there's just one dwelling, for instance, in a mixed-use development, the building amendment regulations apply in relation to combustible materials and fixtures such as solar panels and balconies on the premises. The new Fire Safety Act, which isn't in force, which I was discussing, will be enforced one day in a not too distant future, hopefully, applies to not just residential units, but mixed use, and changes the whole nature of fire safety risk assessments. And the dreaded EWS1 certificates, which mortgage companies are still requiring in spite of perhaps what the government keeps assuring us, apply to mixed-use developments as well. So there are some similarities.
So can you just summarise the statutory control of residential?
Yeah, I mean, it goes back to 1972 and something called the Housing and Finance Act, and it's now in the nightmarish Landlord and Tenant Act 1985. Has been very much amended left, right and centre over the last 36 years. So we really need some sort of consolidating legislation. And again, anybody involved in the management of blocks will know this. It only applies to dwellings, flats and houses. But Section 18 of the Act defines what a service charge is, not word for word, but it's payable directly or indirectly for services, repairs, maintenance, insurance, the landlord's costs of management or improvements, and it varies in accordance with the costs and the estimated costs or the estimated costs. Once you come within that definition, I should stress that the lease must allow it as well. But there's a whole array of statutory provisions. Section 19 says the work must be reasonable, incurred of a reasonable standard. Section 20 incorporates or creates something called the Service Charge Consultation Requirements England regs of 2003 and the Wales regulations of 2004, whereby when you want to charge more than £250 per tenant for qualifying works, then you have to go through several stages, 4 stages of consultation, unless you're dispensed by the tribunal. If you want to enter into a qualifying long-term agreement with a third party of more than a year, you have to go through consultation galore. There's provisions which are much more common than people might imagine. Section 20B, which says if you must demand any money via service charge within 18 months of it becoming due, unless you notify the tenants in writing within that time period that you want to basically extend it. There's requests for summaries of service charges can be made and likes. There's huge amounts of legislation.
Okay, so bearing all of that in mind, you briefly mentioned in the webinar a case called Oak, Fern and Ruddy. Can you just explain the significance of that one?
Yeah, it was quite a shocker of a case at the time, but a lot of people seem to have conveniently forgotten it. It's a 2006 Court of Appeal decision. What landlords will do if there's a mixed-use development is, because they thought they would be able to avoid all the statutory control, which adds quite considerably to the management burden, by having an intermediate landlord, especially in the bigger mixed-use developments, but not uniquely. So you'd be the sort of head landlord, and then you'd grant a intermediate lease of the residential parts to the person who was actually going to be doing the management and collecting service charges. You'd be responsible for the actual work to be done, but somebody else would do all the management side. And then the intermediate landlord would grant subleases to all the individual occupiers, residential occupiers. The background of Oak, Fern and Ruddy, it all took place, as I recollect, on the Fulham Road in London. Most of the cases tend to be London cases, not uniquely. There's a huge, it's obviously an issue elsewhere. Quite a few Manchester cases as well, actually. But the majority of the cases that go, especially to the appeal courts of London, because the amounts of money involved justify it. But anyway, this premises, there was on this particular block, there was a basement which was for commercial purposes, and then a commercial use on the ground floor, and 3 floors of residential units with it's called King's Court Mansions is what it's called if you're ever passing by, Lizzie. And the residential units there was an intermediate landlord called Public Shed Property Management. They then granted subleases, and 15 of the 24 subtenants were members or the owners of Public Shed. Mr. Ruddy, a subtenant of one of the dwellings, wasn't the owner. He wasn't involved directly in Public Shed, but he was concerned about service charge liability and the amounts that were being charged. And he wanted to bring an action, not necessarily against Public Shed, the intermediate landlord, but against the head landlord. Because if he succeeds, it sort of defeats the purpose of the one of the purposes of the arrangement. The Court of Appeal said that, well, in the definition of dwelling and service charge in section 18 that we mentioned, it just says that you have to be a tenant of a dwelling. It doesn't say anything about having to be an individual person and having to occupy the premises. And section 38 of the 85 Act says it applies, the provisions apply to a building or part of a building occupied or intended to be occupied as a separate dwelling. And again, there's no sort of suggestion that it has to be occupied by the individual tenant. And so the Court of Appeal decided that Mr. Ruddy could bring action against the intermediate landlord, but both the intermediate landlord and Mr. Ruddy could bring action against the head landlord. And also the head landlord owes obligations to the intermediate landlord and also obligations to all the individuals. I did mention another case that's underneath it in the notes involving Camden Borough Council, O'Donnell Court, 2016 case, where the landlord was arguing, well, I'm responsible for the work, but the intermediate landlord collects service charge. And this doesn't make too much sense because the intermediate landlord's the one who has the addresses of all the tenants and the likes, and not myself. But the court didn't accept this, or the upper tribunal, to be precise, didn't accept this. You can just, you don't have to specifically name the individual tenant, you can do it generically, and there is always this power to be dispensed from service charge consultation if reasonable. But it's caused more ruptures than people might imagine, actually, in the management of these properties. And we're not just talking about big, multi-million quid private sector properties here. We're talking about housing association properties. The O'Donnell case was Foundling Court and O'Donnell Court was Camden Borough Council. So it is highly significant. That's the first case.
Okay, thank you very much. Another case that you mentioned in the webinar earlier in the week was Phillips and Francis, the Court of Appeal case from 2013, which I believe deals with how you define qualifying works, a point that you just mentioned. Do you want to go into that one?
Yeah, it's always been ever since the early 70s, when the legislation, the pre-85 Act, was introduced, it's always been a bit of a discussion point. Because it's not the best drafted legislation. But as if you remember, Section 20 of the Landlord and Tenant Act says that if you, as a landlord, want to carry out qualifying works and you don't go to the relevant consultation unless dispensed by tribunal, then you can't charge more than £250 per tenant, which could leave you hugely out of pocket, so out of pocket to be in danger of going into liquidation. I suppose the problem, I'll try and explain the problem. There's no definition of qualifying works, and supposing at the same time you're arranging as a landlord for contractors to come around and paint the exterior and the interior, is that one set of works or is it two sets of works? And that's the sort of issue. If you replace, who knows on that one, if you're replacing the roof at the time as you're doing internal refurbishment, are you doing one set of work or two sets of works? And the first instance decision, which was reversed by the Court of Appeal in Phillips and Francis, would have been disastrous for landlords and the managing agents. I'll tell you the background facts if you want, Lizzie.
Yeah, please do. Go on.
I was going to say they can't see you nodding on a podcast. I did we're going to break here anyway. I did a podcast of this. The bloke who was arranging it just kept, didn't say a word. But anyway, we'll start again now. Phillips and Francis, the background was, this was up in Cornwall, actually. It was a holiday park, 25-acre holiday park on the coast in a place, Point Curlew, which is St. Mirren. He's near Padstow, quite swish. There was, I forget the exact number, there was something like 154 holiday chalets on this 25-acre holiday park, plus an amenity centre and 11 lodges, as I recollect. And there's obviously service charge liability. And what happened is, Mr. and Mrs. Francis purchased the reversion of this holiday park. Everybody had 999-year leases. Those are quite substantial things, but they could only be occupied a certain number of days of a year and the like, some planning considerations or planning conditions. They purchased this property in the mid-2000s and thinking to themselves, this has got potential. We'll revamp it enormously. We'll have this swish holiday park and we'll make lots of extra money. So they did lots of work and for over 2 years without any kind of consultation. And that's when the tenants, including Phillips and the other one who features in the case is Goddard, took objection that you haven't, you conducted qualifying works, but you didn't go through consultation. Now, there'd been a previous case from 1999 called Martin and Maryland Estates, which had said that you take a set approach, if that's the sort of expression. Is it part of the same transaction, if you like? And in particular, in that case, all the works were covered by the same contract, which is a strong point to that effect. At first instance, I stress not on appeal. Chancellor Morritt, it was, who was very senior judge, said that that's not so. You look at an aggregate approach. You look at all the work which was done during that accounting year, the service charge year, the charging year, or the charging period, whatever it might be, which caused quite a stir at the time back in 2011, because you're not going to know in advance. Supposing you do some work, it's £250 per tenant before you can carry out the work. Supposing you do £100 of worth of work in that charging year, charging period, you don't have to consult. Supposing you do another £100 a month or two later, you don't have to consult, and then you decide to do £800 worth of work. So you do decide to consult, but the other £200 are added, so you're out of pocket more. And I say this is causing all kinds of problems, and it was not the most sensible way of dealing with it. But in 2013, as you said, it went to the Court of Appeal. And the Court of Appeal basically readopted the set approach. They did say everything's a question of fact. You can't always judge these things. But it was Lord Dyson and then Master of the Rolls who gave the major judgment and stated the factors, which I think are quite good to know for the management people. They stated the factors that you take into account, like the proximity of the work for one. If one's external, one's internal, points against it perhaps. The time, were they done at the same time, or close to one another, or long time away from one another? Are they in any way connected in relation to it? And as in the Martin and Maryland Estates case, are they covered in the same contract? And you take into account those various factors, but you're never going to be 100% certain in relation to it. And that was basically a return to the status quo. Thankfully for the managing agents.
Okay, there was another case from 2013. This one went to the Supreme Court, and it's Dejan and Benson. Do you want to give us the background on that one? Yeah.
This is again reversing the previous decisions, and good news for the managing agents. It was about the fact that the tribunals can exempt you. You can be dispensed of going through the consultation if they deem it reasonable to do so. So most obviously, if there's something like emergency works, you don't have to. You have to apply, but you have to apply to be to go through a dispense. If the roof's just blown up, if you don't do 3 months of consultation before you can start the work. What basically happened in this case is that this was a block in Muswell Hill in London again. It was a smallish block, as I recollect. There were some commercial units down below, and there were 7 residential flats above. So we're not talking the same size as some of the cases I was mentioning in the webinar. It was only 5 of the flats who seemed to have taken objection to this. Days and investments are huge, as you may appreciate, but they needed to do work, the best part of £280,000 worth of works on this premises. On the residential part, again, it doesn't apply to the commercial units. They wanted to do all this work. They obviously have to go through its qualified works. It's going to be well over £250 per tenant many times over. And they do what I've seen happen on huge numbers of occasions. They went through the consultation period, but skipped stages. I'd have an opinion, because I've been looking at this for 15 years of my life, more than that actually, 16, 17 years of my life. I've been doing a lot of this ever since the consultation requirements regs came in 2003 and 4 in Wales. And I'd say a majority of people who are actually doing the consultation are skipping stages. That's significant. The basic stages you have to go through is, if you want to do works within the legislation, you first have to notify the tenant why you want to do what you want to do, and with observations and the likes. The second stage is that you then, or tenants, you wait 30 days and the tenants can, you've got to produce at least 2 estimates and 1 from an independent party, but any of the tenants can nominate another person to get estimates from, in which case you have to get estimates from other people. Then you have to sort of publish the estimates and allow the tenants to inspect them. You have to tell them where and when they can be inspected, and also have regard to their observations. And then fourthly, at the end, you enter into a contract to do the works, and unless you chose the cheapest, that doesn't mean to say the best, or a nominee of a tenants, you have to tell all the tenants within 21 days justifying why you chose who you chose. So it's quite a burden, as you can imagine. In this particular occasion, they started the consultation, but when they were supposed to allow the tenants to inspect estimates, they weren't available for a part of the time. You've got to wait 30 days for the tenants to be able to inspect, and they weren't available for quite a part of that time. And they're supposed to have observations as to the works and didn't. So 5 of the tenants objected. We don't have to pay £280,000 collectively. We have to pay 1,250, 5 times 250. And the original cases, Tribunal and Court of Appeal, agreed with that. You're massively out of pocket. It went to the Supreme Court, and the Supreme Court, I said, it's another one of those that the parties were waiting with bated breath for. The Supreme Court decided, for various reasons, a bit dependent on its facts, admittedly, that you didn't. The landlords did themselves a lot of favours by offering to forego £50,000. But also, the court decided that you've skipped these stages. If you'd have gone through those stages, it would not have changed anything. You would have still employed the same contractors to do the same work at the same price. And also the amount involved was significant. The loss would be so great in comparison with your breach, if you like. And so they allowed the appeal. The tenants had to pay, with £50,000 off the full amount. They did give costs. The landlord had to pay the tenants' costs as well.
So what happens if the works required go outside of the scope of the consultation? There must be cases around that.
There's quite a few, and again, to some extent, it depends on its facts. It might be one of those situations where you can apply to the tribunal to be dispensed of the works. There's so many examples of it where you find that the quote was massively sort of underquoted or whatever, and I've come across examples where you quoted and you find additional work like dry rot or asbestos needs to be removed, this kind of stuff. And one of the comparatively recent cases, 2018, is this case that was on the last page of the notes, but again I didn't mention, a case called Reed Basin Fatal, I think it is, which is a Court of Appeal case. Again, a London case, and bearing in mind this is, we're talking about very expensive properties. You don't tend to go to the Court of Appeal if it's a 50 grand flat or something. This was overlooking Regent's Park in London. Block is number 14 to 112 Nottingham Terrace. It involved 2 particular flats, and they have penthouses. The roofs had the sort of asphalt roof that needed to be replaced. But they had a sort of, the tenants with the landlord's agreement some years previously had tiled the roofs with some expensive tiles. The first tier, I think the first instance, I should say, judge seems to have visited the property and was very impressed by the tiles. I think he's just been nosy, quite honestly. But they got a quote, they went through the service charge consultation correctly, and then found that the quote was inadequate because they planned to sort of remove the tiles. They would spray some chemical, don't ask me about the asbestos, and then replace the tiles. But they were advised that if they did it in this way, any guarantees over the roof would be vitiated. So they had to raise the tiles slightly on a sort of pedestal effect and they went for more expensive tiles at the same time. So I suspect these people are not sure to a bother to. The landlords didn't go through consultation, even though the increased bill for the replacement of the roof of these two units was £31,000, and the tenants argued you should have reconsulted. We don't have to pay more than £250. The Court of Appeal decided that the amount of work involved, albeit £31,000, was only an additional 6% to the original work, and it wouldn't in those circumstances be reasonable to reconsult. The tenants knew full well what was going to happen, just let the landlords walk into it. And the tenants wanted some better tiles that they would pay for and the likes, and it wouldn't be correct to have to retender again. So that was one example where, well, after a lot of litigation, they got away with it. The best thing to do if you have doubts whatsoever is probably to reconsult and or get the dispensation from consultation. So it's a very complicated area. There's huge numbers of cases, not just London cases, but the worst of mixed use. You can start seeing why landlords managers would much rather manage commercial units than residential. That Oakfen and Ruddy case is a highly significant case because it blocks a lot of the sort of capacity for the landlords to limit their liability. And that's it, Lizzie, for another day.
Excellent. Thank you very much, Richard. Thank you, Richard, and thank you to everybody for listening. We look forward to seeing you in our next episode.